Part 10 Defense. Contents of this part. Scope of this part. Rule 10.1 The defendant. Filing defense and consequences of not doing so. Rule 10.2 The period for filing defense. Rule 10.3 Service of copy of defense. Rule 10.4 Defendant's duty to set out his case. Rule 10.5 Consequences of not setting out defense. Rule 10.6 Additional matters which must be included in defense. Rule 10.7 Special requirements applying to claims for personal injuries. Rule 10.8 Defense of tender. Rule 10.9 Reply to defense. Rule 10.10 The defendant filing defense and the consequences of not doing so. 10.2 1. A defendant who wishes to defend all or part of a claim must file a defense. 2. Where a defendant admits liability but wishes to be heard on the issue of quantum, he need not file a defense but shall indicate on his appearance form referred to in Rule 9.4 2 that he wishes to a. Cross-examine any witness called on behalf of the claimant, b. make submissions to the court, or c. call any evidence, in which case he shall file with the appearance form a statement of facts upon which he intends to rely. 3. If the defendant fails to file a defense within the period for filing a defense, judgment for failure to defend may be entered if Part 12 allows it. Part 14 deals with the procedure to admit all or part of the claim. The period for filing defense. 10.3 1. The general rule is that the period for filing a defense is the period of 28 days after the date of service of the claim form and statement of case. 2. However, a. where permission has been given under Rule 8.2 for a claim form to be served without a statement of case, or b. where a statement of case is amended pursuant to Rule 20.1. The period for filing a defense is the period of 28 days after the service of the statement of case or the amended statement of case, as the case may be. 3. In proceedings against the state, the period for filing a defense is the period of 42 days after the date of service of the claim form and statement of case. 4. Where the defendant within the periods service of copy of defense. 10 The period for file service of copy of defense 10.4 when the defendant files a defense. The statement of case or the amended statement of case, as the case may be. 3. In proceedings against the state, the period for filing a defense is the period of 42 days after the date of service of the claim form and statement of case. 4. Where the defendant within the period set out in paragraph 1, 2, or 3 makes an application under Section 7 of the Arbitration Act, Chap. 501, to stay the claim, the period for filing a defense is extended to 14 days. Service of copy of defense 10.4 when the defendant files a defense. The determination of that application. 5. A defendant may apply for an order extending the time for filing a defense. 6. The parties may agree to extend the period for filing a defense specified in paragraph 1, 2, or 3, up to a maximum of 3 months after the date of service of the claim form, or statement of case if served after the claim form. 7. Only one agreement to extend the time for filing a defense may be made. 8. The defendant must file details of such an agreement. 9. Any further extensions may only be made by court order. 10. The general rule is subject to Rule 9.7. Defendant's duty to set out his case 10.5. 1. The defendant must include in his defense a statement of all the facts on which he relies to dispute the claim against him. 2. Such statement must be as short as practicable. 3. In his defense, the defendant must say, a. which, if any, allegations in the claim form or statement of case he admits, b. which, if any, he denies, and LN 301 of 2012. Supreme Court of Judicature of Trinidad and Tobago, 2016. Consolidated Civil Proceedings Rules 2016-69. C. Which, if any, he neither admits nor denies, because he does not know whether they are true, but which he wishes the claimant to prove. 4. Where the defendant denies any of the allegations in the claim form or statement of case. A. He must state his reasons for doing so, and b. If he intends to prove a different version of events from that given by the claimant, he must state his own version. 5. If, in relation to any allegation in the claim form or statement of case, the defendant does not a. admit or deny it, or b. put forward a different version of events, he must state each of his reasons for resisting the allegation. 6. The defendant must identify in or annex to the defense any document which he considers to be necessary to his defense. Consequences of not setting out defense 10.6. 1. The defendant may not rely on any allegation which he did not mention in his defense, but which he should have mentioned there, unless the court gives him permission to do so. 2. The court may give the defendant such permission at a case management conference. 3. The court may not give the defendant such permission after a case management conference unless the defendant can satisfy the court that there has been a significant change in circumstances which became known after the date of the case management conference. Additional matters which must be included in defense. 10.7. 1. Where the defense is filed by an attorney at law, it must a. be signed by the attorney at law, b. give his name and business address and facsimile transmission number, if any. C. If that address is not within 3 miles of the court office where the claim form was issued, give an address for service within that distance. And D. If the defense is filed by an agent, be signed by the agent and give his name and address for service. 2. Where the defense is filed by the defendant personally, or in the case of a body corporate by an officer of that body corporate, it must give an address at which documents may be served, unless he has filed an appearance which includes such an address. 2016 Supreme Court of Judicature of Trinidad and Tobago. 70 Consolidated Civil Proceedings Rules 2016. 3. That address must be within 3 miles of the court office where the claim was issued. 4. The defendant must certify on the defense that he believes that its contents are true. 5. If it is impractical for the defendant to give the certificate required by paragraph 4, it may be given by his attorney-at-law. 6. If the certificate is given by the attorney-at-law, he must also certify the reasons why it is impractical for the defendant to give the certificate and that the certificate is given on the defendant's instructions. 7. If the defendant is defending in a representative capacity, he must say, A. What that capacity is, and B. Whom he is representing. Part 21 deals with representative parties. Defense of tender 10.9 The defense of tender shall not be available unless the defendant pays into court the amount alleged to have been tendered within the period for filing a defense. Rule 10.3 states the period for filing a defense. One. The current Rule 10.2 was brought about by the deletion and substitution of Sub-Rule 2 by Rule 6 of the Civil Proceedings Amendment Rules 2011 Legal Notice Number 126 of 2011. As set out in the 2006 publication, Sub-Rule 2, read as follows. 2. In particular, if a defendant admits liability but wishes to be heard on the issue of quantum, he must file and serve a defense dealing with that issue. 2. The current Rule 10.3 was brought about by the deletion and substitution of Sub-Rule 2 by Rule 5 of the Civil Proceedings Amendment Rules 2012 Legal Notice Number 301 of 2012. As set out in the 2006 publication, Sub-Rule 2, read as follows. 2. However, where permission has been given under Rule 8.2 for a claim form to be served without a statement of case, the period for filing a defense is the period of 28 days after the service of the statement of case. 2016 Supreme Court of Judicature of Trinidad and Tobago. 72 Consolidated Civil Proceedings Rules 2016. Cases. 2015 Privy Council/Court of Appeal. 708 Consolidated Civil Proceedings Rules 2016. 2016 Supreme Court. permission of the Judicial Committee of the Privy Council, which was given by order dated February 15, 2017. 2. The alleged libel is contained in a letter dated October 7, 2009 sent by the appellants to Isle of Man Customs and Excise. Mr. Willers contends that it was suggested in that letter that he had been guilty of gross impropriety in connection with the affairs of Cross Atlantic Ventures Ltd., Cross Atlantic, and other companies linked to a wealthy businessman, Mr. Albert Gubay. Mr. Willers was for many years engaged in the management of these companies as Mr. Gubay's right-hand man, but was dismissed by Mr. Gubay in July 2009. The appellants were also involved with these companies and provided to them tax advice and audit services. 3. Mr. Willers did not become aware of the existence of the letter or its contents until June 22, 2013 or shortly thereafter. The claim form was issued on December 5, 2013, some 5.5 months later and over 3 years after the one-year limitation period had expired. The defense, served on February 10, 2014, raised defenses of limitation, abuse of process, qualified privilege, and justification. It was alleged in the particulars of justification that Mr. Willers had been guilty of serious accountancy misconduct in the period from 1998 to mid-2009, including the inappropriate use of the funds of Cross Atlantic to renovate his home, Balagon Farm in Baldwin. 6. Mr. Gubay died on January 5, 2016. Limitation, abuse of process, qualified privilege, and justification. It was alleged in the particulars of justification that Mr. Willers had been guilty of serious accountancy misconduct in the period from 1998 to mid-2009, including the inappropriate use of the funds of Cross Atlantic to renovate his home, Balagon Farm in Baldwin. 4. Mr. Willers served a reply on June 30, 2014 in which he responded to the plea of justification and denied the letter was published on an occasion the subject of qualified privilege. He did not allege that the appellants were motivated by malice, however. 5. On January 26, 2015 the appellants applied to strike the claim out on the grounds that it was out of time. 2. The publication was made on an occasion the subject of qualified privilege and there was no plea of malice. And 3. The proceedings constituted an abuse of process because they did not serve the legitimate purpose of protecting Mr. Willers' reputation and their costs would be out of all proportion to any damage he had suffered. In support of this third ground, the appellants relied upon the decision of the Court of Appeal in Jamil, Youssef, v. Dow Jones & Co. Inc., 2005, QB 946. Page 3. 6. Mr. Gubay died on January 5, 2016. 7. For reasons it is not necessary to explore, the appellant's application did not come on for hearing until March 3, 2016. It was on that day heard by Deemster Corlett together with an application which Mr. Willers had by that time issued seeking permission to amend his reply to allege malice and to expand his response to the plea of justification. The essence of the allegation of malice was that Mr. Nugent had sent the letter of October 7, 2009 in the knowledge that the allegations in it were false and in order to assist Mr. Gubay to pursue a vendetta against him. Mr. Willers also sought an order under Section 30 of the 1984 Act postponing the limitation period on the basis that the letter had been concealed from him, or allowing the claim to proceed pursuant to Section 30A, essentially on the basis that he had acted promptly since he became aware of the letter and that he would suffer great prejudice were the action to be struck out. 10. The appellants then appealed to the Staff of Government Division against those parts of the decision and consequential order of Deemster Corlett which allowed the claim to 7. For reasons it is not necessary to explore, the appellant's application did not come on for hearing until March 3, 2016. It was on that day heard by Deemster Corlett together with an application which Mr. Willers had by that time issued seeking permission to amend his reply to allege malice and to expand his response to the plea of justification. The essence of the allegation of malice was that Mr. Nugent had sent the letter of October 7, 2009 in the knowledge that the allegations in it were false and in order to assist Mr. Gooby to pursue a vendetta against him. Mr. Willers also sought an order under Section 30 of the 1984 Act postponing the limitation period on the basis that the letter had been concealed from him, or allowing the claim to proceed pursuant to Section 30A, essentially on the basis that he had acted promptly since he became aware of the letter and that he would suffer great prejudice were the action to be struck out. 11. That appeal came on for hearing before Judge of Appeal Tattersall QC and Deemster Doyle. Entitled to exercise his discretion. Page 4. Entitled to exercise his discretion in the way that he did. Damages would be tiny. 9. In finding that it was appropriate to allow the claim to proceed, Deemster Corlett found, in summary, that Mr. Willers had acted promptly and reasonably in bringing the proceedings when he did, that any delay attributable to Mr. Willers had not caused relevant evidence to become unavailable, and that greater prejudice would be suffered by Mr. Willers if the limitation period were not excluded than would be suffered by the appellants if it were. 10. The appellants then appealed to the Staff of Government Division against those parts of the decision and consequential order of Deemster Corlett which allowed the claim to proceed under Section 30A and dismissed the application to strike the claim out as a Jameel abuse of process. 11. That appeal came on for hearing before Judge of Appeal Tattersall QC and Deemster Doyle. On June 30, 2016 they gave judgment, 2 DS 2016-06, dismissing the appeal. In outline, they held that Deemster Corlett had properly considered all of the delay from October 2010, when the limitation period expired, to the issue of proceedings, that he had been entitled to conclude that Mr. Willers acted promptly and reasonably once he discovered the letter, that he had made no error in the way he approached the issue of prejudice, and that it was entirely possible that a court would find that the letter had serious consequences for Mr. Willers, and that he had been entitled to exercise his discretion in the way that he did. The appeal on the Jameel abuse ground fell away, as the appellants had accepted would be the case were their appeal in relation to limitation to fail. 9. In finding that it was relation to limitation to fail. 12. This further appeal is now said to give rise to the following two issues, each of which forms the basis of a ground of appeal. I. When considering the effect of the unavailability of evidence on the balance of prejudice between the parties for the purpose of Section 30A of the 1984 Act, is the court confined to considering only the effect of the passage of time from the date on which the claimant had knowledge that the facts in question might be capable of giving rise to a cause of action? Or must the court also take into account the passage of time from the expiry of the limitation period? 2. When considering for the purposes of Section 30A, 2b, 2 of the 1984 Act whether the claimant acted promptly and reasonably after discovering the cause of action, is it permissible for the court to infer that the claimant acted reasonably when he has chosen not to give evidence to that effect? The legislative framework. 13. The 1984 Act is in all material respects the same as the Limitation Act 1980, as amended by the Defamation Act 1996. Section 30A of the 1984 Act provides so far as relevant. 30A discretionary exclusion of time limit for actions for defamation or malicious falsehood. 1. If it appears to the court that it would be equitable to allow an action to proceed having regard to the degree to which a. The operation of Section 4A prejudices the plaintiff or any person whom he represents, and b. Any decision of the court under this subsection would prejudice the defendant or any person whom he represents. Page 5. The court may direct that that section shall not apply to the action or shall not apply to any specified cause of action to which the action relates. 2. In acting under this section, the court shall have regard to all the circumstances of the case and in particular to a. The length of, and the reasons for, the delay on the part of the plaintiff. b. Where the reason or one of the reasons for the delay was that all or any of the facts relevant to the cause of action did not become known to the plaintiff until after the end of the period mentioned in Section 4A. I. The date on which any of the facts did become known to him, and 2. The extent to which he acted promptly and reasonably once he knew whether or not the facts in question might be capable of giving rise to an action, and c. The extent to which, having regard to the delay, relevant evidence is likely I. To be unavailable, or 2. To be less cogent than if the action had been brought within the period mentioned in Section 4A. Ground 1. 14. The appellants attach a great deal of weight to the reasoning of Deemster Corlett in those parts of his judgment which address the issue of delay and which they say reveal he fell into serious error. The board will therefore consider these aspects of the Deemster's judgment in some detail. But first it is necessary to say a little more about the factual background. Page 6. 15. Mr. Willers received the letter on June 20. 16. It is also to 19. In addressing the latter, claim recently came on for trial in the Chancery. Evidence is likely to be 18. The Deemster then addressed to page 7. 8. Turning now. 32. The cause 20, a little later. The Deemster then expressed his conclusions on the issue of delay in these terms. 28. There is indeed high authority for the first and second propositions for which Mr. Browne contends. In Thompson v. Browne, 1981, 1 WLR 744, the House of Lords was concerned with the proper interpretation of, inter alia, Section 2D, 3A, and B, of the Limitation Act 1939, as amended by the Limitation Act 1975.